let's just start right away so that we can take a lot of the questions, because it's not every day that you get a stellar panelist like this. So let's just start straight away. Let me start by introducing our keynote speaker, His Excellency, the Vice President of Nigeria, Professor Yemi Osinbajo, a professor of law, senior advocate of Nigeria. He's an accomplished scholar, teacher, lawyer, and administrator. I know that if I were to read all of His Excellency's bio, we'll be here for so long. So I'll just keep it short and simple. He is one of the nation's leading experts on the law of evidence, national and regional, corporate commercial law, and public law. And we also have Chief Wole Olanipekun, who is ably represented by Mr. Bode Olanipekun SAN. Mr. Olanipekun has, according to Mr. Bode, sent his apologies that he will not be able to join us, but Mr. Bode Olanipekun will speak to us on the issues. First, Honorable Justice Olubunmi Oyewole also sent his apologies. He's unable to join us because of work constraints, but he sends his message to everyone and says that I should give the House his greetings. Mr. Dele Adesina is here. He's also going to be speaking to us. The principal partner of Dele Adesina, LP, a life member of the Distinguished Body of Benchers, past General Secretary of the NBA, and life member of the NEC of the NBA. He will also be speaking with us. Mr. Femi Falana is also here. Okay, he's still online. Mr. Femi Falana would also be speaking to us, a Nigerian lawyer and human rights activist, a member of many professional bodies, including member West African Bar Association, member NBA, Pan-African Lawyers Union, etc. Professor Chidi Odikalu, we're still expecting him to join us, but he's also promised to be here. He said he will be a bit late. He has to tidy up some things, but he will also join us very shortly. He's a Nigerian human rights activist, lawyer, professor, and writer, former chairman of the National Human Rights Commission, and currently senior manager for the African Program of Open Society Justice Initiative, OSIWA. Mr. Richard Akinola is also here, born in the industry. He's a journalist, human rights, and pro-democracy activist. He's the publisher and editor-in-chief, Corruption Cases Journal. Dr. Ruben Abati will be moderating the speaking session. Nigerian journalist, politician, television anchor, also a man of many parts. It's good to see you, Dr. Abati.
Thank you very much. I'm glad to be here. I'm glad to see my former teacher, the Vice President of Nigeria.
Hello. So I would bring in Mr. Ogunshakin at this point to welcome us and tell us why this topic is very important, especially for us journalists, because virtual proceedings, like we know, the new normal is here to stay, and a lot of us have many questions. I see that there are about almost 50 people online. Okay, 43 people online now. So I know that a lot of our colleagues, the media professionals, have joined in, and we'll get to the question session later. But Mr. Ogunshakin, over to you now.
Thank you, Shola. Good afternoon, Your Excellency, the Vice President of the Federal Republic of Nigeria, Professor Yemi Osinbajo, GCON, SAN, the representative of Chief Wole Olanipekun, my brother, Bode Olanipekun, Senior Advocate of Nigeria, Mr. Dele Adesina, SAN, the former General Secretary of the Nigerian Bar Association, and the person that we regard as disturbing portrayal of the Nigerian legal system, Barrister Femi Falana, SAN.
Beg your pardon.
My teacher, the man who taught me judicial reporting, Mr. Richard Akinola, Dr. Abati, my Oga, the Guardian. It's good to see you here, sir. It gives me great pleasure to welcome everyone to this webinar titled The Media Coverage of Virtual Court Proceedings, Prospects and Challenges. This webinar is born out of the need for journalists, particularly judicial reporters, to carry out their constitutional responsibilities of covering judicial proceedings in Nigerian courts seamlessly. The conference has become crucial particularly now that COVID-19 has changed so many things across the world, even the court system. There's no guessing that the fact that the advent of COVID-19 pandemic has affected systems, norms, institutions, and countries across the world, including our beloved country, Nigeria. The administration of justice system of our country is particularly affected as stakeholders seem not to be prepared for the challenges the pandemic has caused. Even before the pandemic, there have been talks on propriety of electronic coverage of court proceedings to enhance fair hearing and fair trial. Unlike many countries, Nigeria was still grappling and undecided on the video coverage of court proceedings. And then COVID-19 caught up with us. The reality of having our courts to see it virtually also met us in an unprepared state. The Chief Justice of Nigeria and other state chief judges started to introduce practical directions that will allow courts to sit virtually via online mediums like the one we are using now, Zoom. The question that is asked at this junction is that to what extent has the judiciary been able to cope with virtual court proceedings? Is it working for both the judges, the lawyers, and even litigants? The few examples or demonstrations we have seen so far raises a lot of process. As it concerns judicial reporting, only invited journalists have had access to proceedings. It therefore means that judicial authorities cannot select media representatives that they like or that is favorable to their dictates to cover proceedings, leaving out those that are considered critical. Can we then say that such proceedings meet up with the constitutional provision of public hearing and fair hearing? Huh? Section 39 of the 1999 Constitution as amended has various statutory provisions which guide media coverage of court proceedings. Journalists have qualified privilege to cover court proceedings, provided they are accurate and reflect the true proceedings. Some state defamation laws make coverage of, I quote, a fair and accurate report in any newspaper of proceedings publicly held before any court exercising judicial authority within the Lagos state shall, if published contemporaneously with such proceedings, privilege, provided nothing in this section shall authorize, I will quote. There was a recent decision of the Supreme Court which ordered the case to start de novo because a trial court delivered judgment in the judges' chambers and not in open court. Our extant laws also provide provisions for press galleries in courts for journalists' recognition of the media as representatives of people during court proceedings. This is to ensure fair hearing and fair trial in dispute resolutions. However, the new normal situation that we're in, the question that readily comes to mind is, how can the media fulfill its constitutional role in the coverage of virtual proceedings? Has the time not come for video coverage of court proceedings? Will open electronic coverage of our courts not put a stop to corruption in the judiciary? We must bear in mind that an open trial is the greatest asset of an incorruptible judge, just as it is the worst nightmare of a corrupt judge. It is in the light of this that Government International has put together this webinar to discuss the role of the media in the coverage of virtual court proceedings. I hope at the end of this discourse, we all will have contributed our own part in moving a great nation and our great people forward in the quest for a corruption-free, just, and a prospering nation. I hereby welcome you to this epoch-making event. Thank you very much. Shala.
Thank you, Mr. Ogushakin.
Shala.
Yeah. Thank you. I can hear you, Mr. Ogushakin. Thank you very much. Thank you for setting us off with those welcome remarks. I'm going to bring in Dr. Ruben Abati to take over proceedings from here. Egbo, over to you, sir.
Hear me now? Yes. Hello, can you hear me?
Yes.
Shola?
Yes, I can hear you, sir.
Okay, very good. Well, Your Excellency, the Vice President of Nigeria, distinguished ladies and gentlemen, senior advocates of Nigeria and others who are here. I hope that Mustafa, you've been able to invite many lawyers also to this forum who can learn a lot from this conversation around what constitutes the new normal, not just for journalists, but also for society and also the legal community in Nigeria. But without much ado, I would like to invite His Excellency, the Vice President of the Federal Republic of Nigeria, Professor Yemi Osinbajo, SAN, GCON, to present his keynote address. He needs no introduction. He's among friends, he's among family. He's also in the midst of his students. I recall that I was in his equity class at the Faculty of Law, University of Lagos State University many years ago. And we're very happy that he has been able to make time out of his very busy schedule to be part of this very interesting subject, occasioned by COVID-19 and the new reality that the entire world has to deal with. Your Excellency, the Vice President of Nigeria, Professor Yemi Osinbajo, SAN, GCON. You're welcome to make your presentation, sir.
Thank you very much. And thank you very much, Ruben. I'm told that the pride of every teacher is to have prosperous and successful students. So I am extremely proud that my student is prosperous and successful. Thank you very much.
Thank you, sir.
Thank you. Our lead discussant and founder of Wale Olanipekun & Co., Chief Wale Olanipekun, SAN OFR, ably represented today by the managing partner of Wale Olanipekun & Co., Mr. Bode Olanipekun, SAN. Principal partner of Daily Additional LP, Mr. Julius Oladile Additional, SAN. The principal partner of Falano and Falano, Mr. Femi Falano, SAN. The senior manager for the Africa program at the Open Society Justice Initiative, Professor Chidi Anselm Odinkalu. The publisher and editor-in-chief of the Corruption Cases Journal and activist, social and political activist, Mr. Richard Akinola. The moderators, Dr. Ruben Abati and Mrs. Shola Shoyode. And of course, our host and the publisher of Gavel International, Mr. Mustafa Adekunle Ogunshaki. Honored guests, ladies and gentlemen. First, let me thank my dear brother, Mustafa Ogunshaki, CEO of Gavel International, for the kind invitation to participate in this important conversation on the questions around reporting of virtual court proceedings. Reporting of court proceedings is a crucial exercise of the right to fair hearing, a cornerstone of which is that hearings must be held in public. How is it that, how that right will be given full expression when court proceedings are within the encrypted confines of virtual platforms is really the subject of our conversation today. How do we give full expression to the right to public hearing when court proceedings are, within the virtual environment? The attorneys general of Lagos and Ekiti states, I believe, deserve our commendation for bringing the matter before the Supreme Court. They asked the court to determine whether, having regard to the constitutional requirement that court proceedings, except for some exceptions, must be held in public, court hearings by the use of technology, by remote hearings of any kind, whether Zoom or WhatsApp or Skype or Microsoft Teams or any other audio-visual or video conferencing platform, whether any of these virtual platforms, hearing a case by these virtual platforms can in any event be constitutional. The Supreme Court, while dismissing the suits themselves as premature and speculative, nevertheless said that as things stood today, virtual court proceedings are constitutional. This wise approach of the court probably saved our system of justice another catastrophic round of technical decisions around the constitutionality of virtual proceedings. It may also be cautiously taken as a signal that the court expects our courts, the lower courts, to go down this new path with as little attention to technicality as possible. So we're at a point where at least we know that virtual hearings are legal, and this means that the court, and this is the Supreme Court, is satisfied that appropriate means can be found to ensure that hearings are public and that the press and indeed members of the public can access the proceedings. Now, the technical issues around this are straightforward enough. And I'm talking about the technical issues around accessing the virtual platforms. I think that they are fairly straightforward. If, for example, we take the Zoom platform, which we're using now, if this is the preferred option, the host, who may be the registrar of the court, will simply invite the press by making available the relevant coordinates of the meeting to enable the press. And of course, when we say press now, of course, we're not talking about necessarily just the print media, but we'll come to that in a moment. Which will just enable the press or members of the public to log on to the proceedings. Just as the physical court can only sit a determined number of persons, so the virtual court, depending on the platform being used, will probably have a stated number of persons who can, access the proceedings. Practice directions may have to indicate how and in what order invitations will be issued, especially to the public. News reporting today is, of course, no longer the preserve of traditional media. Every blogging, blogger, micro-blogger, and other social networking services are now entitled to describe themselves as the press. And I dare say that they have the same constitutional protections as the traditional media would have, given that our definition of freedom of expression does not restrict this in any event to the press, as we understand that word or that expression. But this also means that all of the bloggers and micro-bloggers and all people on Twitter and all the users of of social networking services are also subject to the same restrictions and liable to the same sanctions as the traditional media if they violate the laws respecting issues of confidentiality, avoidance of prejudging cases, scandalizing witnesses, jeopardizing fair trials, by media trials, and all of the various violations that are possible. I think we're in an interesting place because in the past, it was always the traditional media that could be accused of violations or could be sanctioned for violations. But now it seems that practically everyone on social media who chooses to publish or publicize the proceedings of a court, not the comments after the proceedings, but actual proceedings of the court, and report the proceedings of the court, will be subject to the same restrictions that the traditional media have always had through the years. In 2018, a British court jailed for 18 months the chair of the UK Legal Defence League, Mr. Stephen Yaxley Lennon. I think he also calls himself Tommy Morrison. Now, here was a man who was broadcasting on social media outside the Crown Court in Leeds in the UK, where a trial was taking place. He was accused of broadcasting live, right? And within hours of this broadcast, over 500,000 people had viewed the broadcast. And the court felt that his actions could have cost the court the hundreds of thousands of pounds in rerunning the trial because of the prejudice that was introduced by his reporting of the case live in the manner that he did. Now, the questions here, of course, is where are the limits? And I hope that these are the questions that will be considered. Where are the limits to the sort of reporting that will take place? Because when you have a virtual recording, such as we have here, practically everyone, of course, actual recording of it can be controlled by the host. But it is possible, for example, even if you are controlling recording, if our host today, Shola, is controlling the recording and is not allowing us to record, it's possible for me to have my own little camera, just my phone here, and I can record everything that has been said and done, which is also possible for the virtual trial. And I can run, I can actually, immediately broadcast this on social media. Now, these types of problems and these types of situations are what perhaps practice directions may have to address. What are the limits? Clearly, no one is allowed except with permission to publish live proceedings of a court. But, we need to really determine how this will work. We need to ask the relevant questions. And I think that in developing these practice directions, the media has to very quickly occupy the space so that the courts do not, without adequate information and without adequate sensitivity to the rights of the press and all of that, do not develop a set of practice directions that create more trouble than they are designed to solve. So I think that this is one of the reasons why these sorts of conversations are important, because I hope that the proceedings of our conversations here will go possibly to the Supreme Court and possibly to the chief judges of our courts, so that they get a sense of what needs to be done by way of practice directions and what the problems and issues may be. Obviously, just by way of the sorts of considerations that the media ought to have in reporting virtual proceedings. Of course, there are system requirements that have to be looked into. It's not enough for one to simply say that I have access or I'll be given access. We have to look at all the system requirements. What I've found in the past few months, where I've been involved in quite a few Zoom meetings or WebEx meetings and all of these different platforms, is that very often, if the devices on either side are not adequate or the bandwidth is not adequate, it just becomes a mess, and it's impossible to actually get the best get the best quality. So I think it's also important for some kind of standardization, so that there is the equipment that we use are the right sorts of equipment that should be used for the purposes of these virtual court proceedings. By and large, my belief is that we are at a very interesting place in court proceedings. We have all been talking for years about computerizing our court systems, e-filing, etc. No one knew that we would quickly come to the place that we're in today. So in some senses, thanks to COVID-19, we have been very quickly dragged into the virtual space. And I think that it's a good thing that is the case. One of the questions that I would want to ask is that, and I alluded to this in some other webinar, which had to do with justice reform, is a whole question around what type of platform will really serve our purposes in court proceedings? What type of platform? I know that several people already use virtual platforms for arbitration. But for purposes of trials, I'm not so sure that this Zoom platform or these sorts of platforms are the best, because we have to look at situations where we're examining witnesses, we're showing them documents, we're referring them to various documents. What happens in those situations? Do we suspend the rules of evidence or, you know, some of the rules of procedure. I mean, how does a photocopy of a document look virtually? If you show me even an original document virtually, is it still an original document, or is it a copy of an original? You know? So there are issues that we need to resolve. We will need to resolve several issues of procedure and several issues, you know, of evidence, just so that we're, you know, better able to navigate these proceedings in a manner that not only serves the ends of justice, but also we're in some obedience to the law. I think that an opportunity that this offers us is to get rid of as much technicality as possible. This is the opportunity that we are offered. And I'm so pleased that the Supreme Court did not even hesitate in saying that, well, as far as we're concerned, virtual proceedings are legal. I mean, it was really a breath of fresh air, considering the way that we tend to magnify technicality, you know, to the point where sometimes you wonder where justice is, you know, when technicality assumes such huge dimensions. So I am hoping that the opportunity we have in virtual proceedings will also be an opportunity to dispense with several of the unnecessarily technical rules that we have in our adjectival law, in our laws of evidence, laws of procedure, and all of that. And hopefully we'll be able to get to the heart of trials and get to the heart of the matter so that we're not bogged down unnecessarily by technicality. So I would end it by saying, again, my thanks to the Gavel International for putting this very important conversation together, and to hope that this will be won't be the last of these kinds of conversations, especially around virtual court proceedings, because I think the implications, especially for our procedural laws and all that, are so broad and so deep that we must certainly engage even much deeper in order to be able to arrive at a system and a framework that will work, especially for the ends of justice. Thank you very much. God bless you all.
Well, thank you very much, Your Excellency. I'm sure we've all listened to His Excellency, the Vice President of Nigeria, Professor Yemi Osinbajo, who is here, not as Vice President, but as a member of the family of lawyers and stakeholders addressing a major development within the legal community. COVID-19 has changed everything. It's not only in Nigeria, in Canada, in the UK, and in other jurisdictions. They are having, distant hearings in the courts. But this, of course, presents special challenges. I will not try to summarize what His Excellency has said, but he has raised quite a number of issues. You recall that in March, April, when those practice directions came up, there were objections. And I read two notable essays, one by Michael Zekuma SAN, one by Awumolo SAN, where they raised questions about the constitutionality with regard to Section 36 of the Constitution, whether indeed virtual hearings will pass the test, the technical test of the Constitution saying hearings should be held in public. His Excellency has pointed out that the Supreme Court has settled that matter. But there are questions that have also been brought up. What type of platform is most appropriate? Zoom? Is it Skype? Is it video and audio recording? How about rules of procedure? How about technical details? And then, of course, where is the place of the media in all of this? The media will be invited. You can only come strictly by invitation. So who represents the media? Who determines who should get invited? Is it the mainstream media? Is it the social media, which is now so ubiquitous? And then, of course, what are the implications for journalistic system? We have a strong in our various courts in terms of how the courts can comply technically. I think it was the Chief Judge of Oyo State who raised the question about saying, look, the courts in Oyo State are not prepared for virtual hearings. So there are many issues, but we have a number of discussants. And quickly, I would like to invite the representative of Chief Wole Olanipekun to make his own contribution. He has 10 minutes. I mean, we can't ask the Vice President questions because he's a keynote speaker. So keynote speeches are what they are. They set the tone. They would like to see some of those issues that have been raised, responded to. So I'd like to invite very quickly Dr. Olanipekun, who is representing his dad. And I see that he looks like a split image from what I've seen on the screen here. So Dr. Olanipekun, SAN, over to you.
Thanks. Good afternoon, everyone. Just to correct a quick impression, I'm not the doctor.
Oh, okay. I know there's a doctor there. Yes.
Yes.
But it's okay.
Your Excellency, the Venerable and Venerated Professor Yemi Osinbajo, Grand Commander of the Order of Niger, Senior Advocate of Nigeria, Vice President of Federal Republic of Nigeria. I'll stand on the protocol list established by Mr. Vice President. Again, I'll apologize on behalf of Chief Olanipekun, SAN, who has to chair the council meeting of the Ajayi Crowther University. The university is going through a selection process for a new vice chancellor, and that had been pre-scheduled before this event. So please bear with me. Take me as Chief Olanipekun, and I'll say that, as we say in briefs, that except a contrary intention is expressly evinced, references to I will mean references to Chief Olanipekun. So I'll go straight into the topic, and I'll start with a decision of the Court of Appeal in the UK. That's the case of Regina versus City of Westminster. Now, it was a case that related to the extradition of British citizens, and the media had applied to court for classified documents, as it were. And I'll just read out, it's a 2013 decision of the England and Wales Court of Appeal. This was the case made out by the media. They had said, since it had become common practice for courts to be supplied with documents before a case was heard, and for judges to read them beforehand in the interest of efficiency, it was not possible to understand the full case against those extradited without seeing those documents, which included affidavits, witness statements, and correspondence. And as a result, the claimant was hampered in its journalistic purpose of stimulating informed debate about matters of public interest, including the way the justice system dealt with cases of suspected international corruption and the extradition of British citizens to the United States. So essentially, the case made out by the claimants, the journalistic outfit in that decision, was that the media was entitled to equal access with the courts to court documents, including classified evidence. And this was the decision of the Court of Appeal. I mean, the trial court, the High Court, refused that request. And the journalistic outfit applied for a judicial review of that decision. And this was the decision of the Court of Appeal. The Court of Appeal said, to ensure that evidence communicated to the courts is communicated to the public, the media must be given access to the evidence which the court itself has. So, of course, the Court of Appeal agreed that the media had equal access to public documents, or to well, they are public documents anyway, to documents tendered in court as the court itself had. I would refer to some Nigerian cliches. There's the decision of Kotoya and Central Bank of Nigeria, which Of course, lawyers usually refer to these things said in those cases, that one, justice must not only be done, but manifestly and undoubtedly be seen to have been done. There's another one we usually refer to. We say that when talking about fair hearing, that every, and this is a decision of the Supreme Court, in Amaka Agu GSC, in Kotoya and CBN, 1989 decision. Every reasonable and fair-minded observer who watches proceedings should be able to come to the conclusion that the court or other tribunal has been fair. So every reasonable and fair-minded observer should be given access. Two further decisions of the Supreme Court, Menakaya, Nuwu, and Ogele, and by some coincidence, Chief Wale Olanipekun was the one that pushed the point in Nuwu and Ogele that the Supreme Court accepted. Now, decisions had been given in chambers. In Menakaya and Menakaya, both parties actually proposed that the proceedings be taken in chambers. And one of the parties turned around to ask that those proceedings be nullified. And the Supreme Court agreed to say that, look, that proceedings must always be in open court. What's the point I'm trying to make? Our judicial system, from the pronouncements of the Supreme Court, completely abhor secrecy. Our judicial system completely abhors secrecy. So, His Excellency the Vice President has posed a question that what is the extent of access? I will want to suggest that that extent should be total. Now, total access, including availability of public or of recordings of court proceedings. Those recordings should be made publicly available. And to be honest, this actually will increase the level of transparency and will change some of those principles that have sort of come to stay for some reason that is not supported by justice. One of them is this, that only a trial court judge, a trial court judge's assessment of evidence is almost infallible when it comes to issues of demeanor of witnesses. So imagine a trial judge saying something like that, I observed the witness. In reaction to difficult questions, the witness was sweating with sweat drops as thick as blood and was looking all around the court for help to see if he could get a wink from or some help from anybody in the public or anybody in court to give a direction on how to answer questions. If a judge wrote that about a witness, trust me, it is almost impossible in the system we're on to upturn that decision. But this is one of the things that virtual hearings have introduced or have opened their eyes to. If proceedings are recorded, that type of decision can be challenged if indeed it's not true. So for me, I think that there are obviously issues that are very fundamental issues with access, total access for journalists. Look, we've heard issues of misrepresentation, prejudicing the minds of the public and all that. But we were all witnesses to the Oscar Pistorius trial in South Africa. This trial ran on TV for the full glare of the world. We saw and understood how the justice system worked in South Africa. I believe we should replicate the same thing locally. And in closing, because I'm at the 10-minute point, His Excellency made a very important point as to public hearing being given full expression to public hearing. Now, and I'll just make a quick reference to, and this is personal now, not Chief Olanipekun's views. At about 2004, when I was writing my long essay in the University of Lagos, of course, I was using Mr. Femi Falana's library and discussing with him because I wrote on the right to life. And the basis of my presentation was that the right to life had to have certain minimum standards of satisfaction before that right to life could be meaningful. Now, we talk of public hearings. If public hearings will be given full expression, the process for the appointment of justices, of judges, of the trial courts must also be made public. Because the truth of the matter is, it's a complete chain, it's a process. Adjudicating is practically at the end of that chain. The process starts with selection of judges. And that process must be transparent and also accessible to the public to give full expression to fair. Thank you very much.
Well, thank you very much, Chief Wole Olanipekun, represented by Olanipekun. I think that, we're back to where the Vice President started from, when he said we're at an interesting place with COVID-19 and remote hearing of cases, or if you like, virtual hearing of cases. You have raised, yes.
Yes. Can you quickly permit me to introduce some of the people that have joined us for this webinar?
Okay.
We have Emeritus Professor Ralph Akinfeleye of University of Lagos. He's on to us in this webinar. We have the former Attorney General of the Federation, Chief Bayo Ojo, Senior Advocate of Nigeria, is with us too. We have Mr. Ayo Olariwaju of the Nigerian Weekly Law Report. We have Dr. Israel Oviri, Mr. Akim Afolabi, SAN. We have Barrister Joseph Obari, the head of the judicial desk of the Guardian newspaper, Mr. Joseph Oyekwere. Sitting in-house with me is the judicial editor of The Nation, Mr. John Mashuku. Mr. Peter Foliotu is here. And linking us is these days Mr. Jude Banoy. And the Punch, Mr. Oladimeji Rahman. Also, Mr. Olubenga Shoele is with us. Thank you, Doctor. Please, you can go ahead.
Yes, thank you very much. And all the persons joining us are welcome. We're having an interesting discussion about how COVID-19 has placed even the judiciary and other sectors within society in an interesting place, to quote the Vice President, who has been the keynote speaker. We've listened to Olanipekun SAN, and he has even extended the discussion to even talk about the selection process. He has also talked about, look, if it's a process, if justice administration system is a process, then there must be fair hearing, there must be openness, there must be transparency at all levels. Now, some persons previously have even gone further. If there must be a recording of the process, either by video or whatever, what is the guarantee that our courts will not be victims of epileptic power supply? What is the guarantee that the parties that have been invited have relevant data, strong enough data? Now, how do you cross-examine witnesses, particularly people who are in the rural areas? If you are doing remote hearing of cases and you have the witness in the rural area, how do you deal with that? And what kind of technical infrastructure do we have in place to even deal with visits to the locus inquo? These are some of the questions that some of the commentators on the subject have raised. But we're beginning to have, make some headway with the various contributions. And very quickly, I would like to invite Dele Additional SAN, who is also part of this conversation. Sir, you have 10 minutes. Dele Additional SAN, please.
Thank you very much, the moderator. Your Excellency, the Vice President of Federal Republic of Nigeria, Professor Yemi Osinbajo, Senior Advocate of Nigeria, I pay my respects, sir. Other speakers, please permit me to observe our protocols. Now that the moderator has already said part of the challenges that I listed here, including epileptic supply, power supply, and issue of training, not just of the journalists, but also more importantly, of judicial officers. I will just go straight to a few other points. First and foremost, I want to say it is no longer in dispute whether virtual hearing conforms with the fair hearing provision of the Constitution or not. As of today, we can say that the Supreme Court has made that to be pointedly clear. And I've never been part of those who think that virtual hearing actually offends the provisions of the Constitution. If 4, 5, or 10 journalists can enter the courtroom while a court proceeding is going on and then blast it to the world in their respective newspapers, either offline or online, and that one satisfies the public hearing provision of the Constitution, virtual hearing that can be watched by over 150 or 100 or over 50 people cannot be less public. As we're in here, we have already about 75 participants at different locations going along with what we are doing. Say that media coverage of proceedings, as far as physical hearing is concerned, there's no problem. For virtual hearing, the problem that one can note will be how do we get access? And that point was eminently made by the keynote speaker, His Excellency the Vice President. And like it has been suggested, all that we need is effective dissemination of access links. Whether this is going to be done by the registrar of the court, or there will be a person appointed that will stand by at the computer department of our respective judicial divisions. This will have to be thought out. Now, very importantly, I believe that this issue is not an issue of sporadic, jumping it into. It is a thing that requires very careful planning. We need a very careful planning, not just at lower levels, even from the topmost level of the National Judicial Council and then down to the office of the Chief Justice of Nigeria. There has to be a formula for implementing virtual hearing in our courts. There has to be an organized arrangement for training of judicial officers. It will be presumptuous for us to think that everybody is computer literate, including registrars. So there has to be well-ordered training. There has to be supply of equipment, standard equipment. No judge can sit on a virtual hearing with his telephone, whether it's iPhone or Samsung or what have you. We need a standardized equipment. And that also brings in the issue of adequate funding for the judiciary. All these things are very, very key. The other time I was in a court, even in a physical hearing before the coronavirus pandemic, and at a point everybody was sweating like very seriously. We men were able to pick our handkerchief and we were trying to clean our faces. But her ladyship, who was presiding in the matter, couldn't do what we were doing because of her painting and what have you. At a point, we had to adjourn. Why? Because there was no power. That's why I said the moderator has highlighted one of the challenges that I see as capable of confronting the virtual hearing thing. Now I go specifically to the issue under discussion, which is media coverage. And I adopt all that has been said by His Excellency the Vice President, as well as the lead speaker, Chief Wale Olanipekun, represented by Bode. So I want to take the discussion to another level. Maybe not limiting ourselves to reporting by journalists. Are we not up to a point where our proceedings can even be covered live? In other words, live coverage of court proceedings. Is it workable? Is it possible? And if it is not possible, why is it impossible? We all watched O.J. Simpson's trial, which took place in faraway United States in America. So many people in the world were part of that proceedings. And if we can just gravitate towards live coverage of our courts, the advantages that I see there are much more than the disadvantages. One of such advantages is that it makes everybody to now begin to see how the court works. And then it reduces the danger and the destruction that media trial has done to our cases. There have been a lot of judicial decisions against media trial, but we still see it. In Nigeria today, all that you need to do is to be accused of one offense or the other. And then on the pages of newspapers, you're already convicted. And when the decisions of our court run counter to the decision reached on the pages of newspapers, all manner of allegations begin to fly about. So, as it has been mentioned by somebody, for a corruption-free judiciary, I believe live coverage of our proceedings will be a great advantage. Number two, it will also very substantially increase the trust and confidence of the people in our judicial system. Today, I make bold to say that we have crisis of confidence in our courts. And everything has to be done to ensure that we galvanize the trust and the confidence of the people in the system. A situation where we begin to have a live coverage of our proceedings, we add very enormously to galvanizing trust and confidence in our judiciary. And like I said earlier, it will put an end to media trial. Now, it is important to also add that the requirement of the law, it cannot be overemphasized, is that justice must be done, and it must manifestly be seen to have been done. But they quoted some authorities along that line. We cannot say that justice has been done when you do not know how the presiding judges or justices arrive at their decisions. A live coverage of our proceedings will also satisfy this constitutional requirement more than mere reporting. We have seen different instances where reporting of proceedings in the court by journalists, either they have added to it or they have taken away out of it. Somebody once said that, don't believe they say, because they say may not be available to say what they say when they say is called upon to say what they say. When you are reporting what has happened before, there is no certainty that you are reporting exactly what transpired in court. So I have just decided to take this conversation to that level because I know that the earlier two speakers before me had really dealt with the topic itself, media coverage of virtual proceedings. But in addition to virtual proceedings, can we begin to fantasize on media coverage, live coverage of our proceedings? It doesn't have to be simultaneously as the proceedings are going on. But if recordings are made, as we're doing now, and is transmitted later, it is still a live coverage of the proceedings. I'm aware that I'm limited to only about 10 minutes, but let me say that the conversation on virtual hearing will continue for many, many months to come. But one thing, if there is only one advantage that coronavirus has brought, if there is only one opportunity which the pestilence has occasioned, it is in introducing technology into our life. It has become a normal thing, and I believe we will continue to grow and become expert in it. But finally, sir, a lot is involved. I don't believe in fire brigade approach to issues of life. I don't believe in sporadic movement. I believe in a calculated movement. So we need a well-coordinated instrument to be driven by the National Judicial Council, the Chief Justice of Nigeria, along with the chief judges of all the states of the Federation, to really come up with a formula, with a practice direction to guide virtual hearing and to ensure that all that are required, including adequate funding, training of the judicial personnel, equipment provisions, and the structure of the buildings themselves, in case there's going to be a restructuring, they are all part of the things that have to be taken into consideration. It is not just a journalistic approach or judicial approach, a funding approach, but also engineering approach is involved. Thank you very much. I'm very grateful.
Well, thank you very much, Mr. Dele Additional, SAN. You've indeed raised quite a number of issues. You're absolutely right. Technology now defines our lives as we try to deal with this public health, global health crisis. And that's probably why the telcos, technological companies, tech companies across the world are the ones making all the profits at this time. You've also raised a question about funding, and I think that's important because if you are going to have live coverage of court proceedings, as you've recommended, you will have to pay the media houses to have that live coverage, whether it is simultaneous or it comes later. And you're also right about providing the necessary infrastructure. But to take the conversation further, I would like to bring in Mr. Femi Falana, SAN, who is also, very knowledgeable about media operations. What are the expectations from journalists? You said judicial officers, the registrar and all the court officers need to be trained. Journalists also need to be trained. Just as, judicial officers have their own rules, journalists also have their own rules of the game. So what are the expectations of lawyers? How do you deal with the issue, for example, of
You have a problem with noise?
I think we have a problem.
Yeah, we can. Hello, Mr.
Can
Falana.
we hear him?
Can you hear me, Mr. Falana?
Yes.
Okay, sir. Just before you come on, sir, can I quickly introduce others that have joined us? Professor Shidi Odikalu has just joined us now. And Mr. Gbenga Oyebode, the CFR, is in the house. Mr. Olushola Ogushake from Canada is here. Mrs. Adiola Fashuba is here. Mrs. Ayotomi Fashui is here. Mr. Bamidele Johnson, Mrs. Bamitale Erile, and Dr. Ishe Oluwage. They are all here. Thank you very much, sir. Please, you can go ahead.
Ruben, can I go ahead?
Mr. Falana, I think you should go ahead since we've lost Dr. Abati.
Okay. Yes, thank you very much. The Vice President of the Republic, Professor Ishibajo, SAN, GCON, distinguished colleagues, ladies and gentlemen. Let me start by saying that we are not a serious people. Nigerians are not a serious people. Please, can you hear me?
Very well.
Yeah. Following the...
Mr. Falana, hello?
Yes?
Mr. Falana,
Yes?
it would be good if we can see your face too for the benefit of those that are recording for coverage, for usage on their TV. Thank you.
All right. All right, I thought you needed my voice. You know, but on a very serious note, after the decision of the Supreme Court in the case of AG Lagos and AG Federation, I thought this matter.
We don't
no,
see
don't
you.
worry, don't worry. No, you will soon see me. I thought this matter had been settled. And said to one or two of our judges, some of our chief judges, can we take advantage of the vacation to put the necessary machinery in place? Can we ask the government, because the central bank claims to be giving out intervention funds to organize business, SMEs, and the rest of them, can we therefore make a special requirement, a special arrangement, special request to the government through the central bank to make money available to the judiciary to put the necessary infrastructure in place? Just last week, the central bank claimed to have disbursed about 360 billion naira to various sectors, in the system. Not a dime has gone to the judiciary, where all the disputes will be referred, the business disputes and the rest of them. But unfortunately, our judges, the judiciary has not made a case. The Nigerian Bar Association has not made a case. In fact, I think that organization is busy with manipulating elections. They cannot have time to address serious issues. If we are therefore gathered here, we must not behave like the government of the day that goes around making demands when it should really actualize, practicalize its programs about slow pace of trials, conflicting court orders, appointment of judges, because these were the serious issues addressed by President Buhari in the last conference of the Nigerian Bar Association. And I asked myself, why do we have slow pace of trials? Because the government and the president was saying, why can't we have criminal cases disposed of in 12 months? That is not possible because we're not ready to embrace technology in the administration of justice in Nigeria. And what do I mean? No funding of the judiciary, no funding for the Ministry of Justice to recruit enough lawyers, trained lawyers that will embrace technology and move cases forward. Our courts officials are not trained. Our judges are not trained. So we're not prepared to move. So the president cannot go public and be complaining about slow pace of trial. Take, for instance, the Administration of Criminal Justice Act has made provisions for fast-tracking criminal trials in our country. And one of the issues provided, even before COVID-19, was that every police station shall have a recording gadget so that if a suspect wants to make a confession and statement, section by the president has to do with the APC. 8 crisis in the APC. After that matter was, the ruling federal government has not brought to book all those who engage in shopping for court orders around the country. The last one on appointment of judges. What has the administration done to improve on the method of appointing judges? This seniority matter. This government has been critical. This government has said, go around the country. The president was saying that, look for the best judges. But are we ready to do that? Just 2 weeks ago, the president was commending to our heavens an attorney general that was appointed in the state of Alberta in Canada. But let us ask ourselves here, can an indigenous of Ogun State are we pretending? Just May this year, a Nigerian lawyer was appointed a justice of the Supreme Court in Ghana. Tanko Mamadou. We were together in Akaba Sharon's chambers. He's from Kaduna State. He's a justice of the Supreme Court of Ghana. Is that possible in Nigeria? So why are we deceiving ourselves? Even the most embarrassing one, because I want to go practical. The most embarrassing one is that there is a Judicial Commission of Inquiry going on in Abuja on the alleged malfeasance of the EFCC suspended the acting EFCC chairman, Mr. Magu. That panel, that Judicial Commission of Inquiry, is headed by a retired justice of the Court of Appeal. For the first time since 1914, following the amalgamation of Nigeria, this is the first time a Judicial Commission of Inquiry is sitting in camera. And nobody is complaining. And that is a regime that is talking of, oh, slow pace in the administration of justice, opacity in the conduct of trials, and so on and so forth. Please, let us go practical and appreciate that we are not a serious people. Now, I'm happy I've seen my friend, Professor Chidi Odinkalu. We have been going to the African Commission since the 90s. And we have taken some of the most serious cases from Nigeria and Africa to the commission. I have never appeared before that commission to make any submission. All our documents are sent to that court, that commission, online, just by, just you either scan or send by email directly. Who were sentenced to death under the late Maman Gaddafi. We filed a petition before the African Commission. And while the petition was pending, we asked for a provisional order, like an interlocutory order, that pending the determination of my complaint, no, I think it was Sarah, I was the lawyer, of the complaint, Maman Gaddafi should be restrained from executing the Nigerians. Happily, it was then the chair. He became the chair of the AU. And we now wrote to him, show leadership by example. And on that basis, I'm talking, I didn't leave Lagos. President Gaddafi decided to pardon the Nigerians and send them back home. Now, I didn't leave my office. Now, I have been appearing in the African Commission, representing people since 2006. I have only made one appearance in that court. Incidentally, Professor Odinkalu was there. The court asked us to come once. And since then, the court has been taking cases without asking lawyers to come. And again, that court is giving decisions that we are citing in our courts. Another one. Between May and July this year, before the ECOWAS court in Abuja proceeded on vacation, I handled 3 cases through Zoom. I sat down in Lagos. The lawyers, some of the lawyers were in Liberia, one in London. The court was sitting in Abuja. And we made our submissions. The cases have been adjourned for judgment. Heavens will not fall when they deliver their judgment. So I can't understand some of the submissions here. We are just creating problems for ourselves. And we are not prepared to address this problem other than just to recite problem. If we are gathered 3 years' time, it will be the same thing. Oh, epileptic supply of electricity. Where do you have electricity in Abuja? Yet, a court is sitting in Abuja. And that court is hearing people from all over the world. And we are gathered here to say, oh, until we have network everywhere, we are not going to move. Now, what do you mean by producing documents? Oh, please, we have moved beyond this level. If you want to go and look at the original, go to the lawyer's chambers, please. What is now done internationally is to scan the document. If you are challenging the authenticity, there's a procedure for raising that. But don't let's sit down here and say, oh, everybody must be brought to the court. We must look at your face, the demeanor. How many courts look at anybody's demeanor? We're just deceiving ourselves. Please, let us move very quickly and see how we can address the problems that have been raised. Please, for journalists, you must insist under section 36 of the Constitution, section 36(4). All hearings, there shall be public hearing. So anybody who does not want public hearing will have to amend the Constitution. There are exceptions to the rule. There are exceptions to the constitutional provision. If you are dealing with children, if you are dealing with security of a country, those are the limitations with respect to public hearing. So we can't sit down here and say, oh, we are not going to have a Zoom hearing. We are not going to have virtual hearing because we don't have the gadgets yet to promote this. What else are we looking for? When the Supreme Court has ruled that service by WhatsApp is proper service now, because we must move with time. I therefore would like to submit that journalists have a duty to demand public hearing. Stop saying sources close to Salami panel, sources close to this. You, the law, I beg you, use the law. Use the Freedom of Information Act to ask the Attorney General, why is this Judicial Commission of Inquiry not sitting in the public? And they must give you an answer within 7 days. But please stop all the funny things, that all the issues we are raising to frustrate ourselves. I mean, can you imagine, for instance, that a Judicial Commission of Inquiry headed by retired President of the Court of Appeal is examining cases pending in regular courts? And nobody is talking because everything is done in camera. One of the cases that I've read in the Punch was a case decided which ended in 2004, the Tafa Balogun's case. Somebody was alleged to have gone to the tribunal 2 weeks ago. Oh, 3 of my houses were seized and they were mistaken for Balogun's houses. That case ended in 2004. Please, let us take ourselves very seriously and move our courts, our heads of court, following the directive of the NJC. Our heads of court have promulgated practice direction for all our court. Our lawyers are the ones saying now, sorry, and my network is not good. I don't want Zoom hearing. I don't want virtual hearing. And we must get a bar association or a group of lawyers that will, after this meeting, after this very important virtual conference, we must get lawyers to go out and challenge our colleagues who are trying to drop back the hand of the clock. Why must a lawyer go to Abuja from Maiduguri? Why should I go to Abuja from Lagos to go and move a motion when that motion, the law says, even if I don't come to court and my case is fixed for hearing, my brief can be adopted in my absence? So why are we now pretending, and why are we now challenging the constitutional validity of virtual hearing? I therefore want to challenge journalists. Don't be made to believe that certain proceedings are confidential. It's a public trial, public hearing, and it shall be made public. If you have any objection as to why it should not be reported before the whole world, then you have to advance adduce reasons. But we are not in England, where judges can harass journalists for reporting, for broadcasting proceedings. Our law has allowed that. We have a constitution that allows coverage of proceedings, and we must go along that line. I beg you. I mean, the last one is a case now. A Nigerian has been sentenced to death in Kano. Next week, 10th, that will be the last day the man can appeal. But the court has not made the judgment available. But because of public hearing, I sent a lawyer to the court and we made it public that the judgment has not been given. That Sharia court deceived the whole world yesterday by saying, oh, we have given the record to Mr. Fallon. We have given him the judgment. I have a lawyer there now to confront them with what has been sent to the whole world. No, you haven't made it available. So please, we shall make it available today. So we must have public hearing. We must have journalists do their work. And please, for me, Ruben, if any journalist or any media house is frustrated from reporting proceedings of our court, let us know. We'll go to court and challenge such opacity in hearing in our court. Thank you very much.
Yes, thank you very much, Mr. Femi Falana, SAN. Clearly, we are in an interesting place. I keep quoting that phrase. But Mr. Falana has been very consistent on this matter. I recall the last time he was our guest on the morning show. He disagreed with those lawyers who claimed that virtual hearing amounts to a violation of Section 36. But of course, in spite of the Supreme Court judgment and in spite of what we have seen, there are some lawyers who are still saying that for this to become truly established, while there is COVID or post-COVID, that there may still be need for constitutional amendment. Now, Mr. Falana has also helped to bring the conversation right into the domain of journalists and the need for journalists to do their work. However, the point he made about sources, well, journalists will always quote sources because a journalist is as important as his sources. I think there's even a famous ruling by the legendary Lord Denny in that regard that, journalists will have to rely on their sources. So if we're quoting sources with Justice Salami, it's not a violation of professional ethics. But at this point, I would like to bring in somebody who is on both sides of the aisle. He's a lawyer. He's also, at the same time, a veteran judicial reporter who can help us address some of the issues, particularly with regard to the point I raised earlier about manipulation of the proceedings, photoshopping, particularly by social media avatars who may have some other interests beyond what are the ethical guidelines of journalism as a profession. Richard Akinola, clearly I'm talking about you, and I would like you to just come in here and help us bridge the gap between judicial procedures and journalistic ethics.
Well, thank you, Ruben. I think let me start with a quotation from Lord Denning in his book, Road to Justice. It says, and I quote, "In every court in England, you will, I believe, find a newspaper reporter. He notes all that goes on and makes a fair and accurate report of it. He is, I verily believe, the watchdog of justice. The judge will be careful to see that the trial is fairly and properly conducted if he realizes that any unfairness or impropriety on his part will be noted by those in court and may be more conscious to give a correct decision if he knows that the reasons must justify themselves at the bar of public opinion," unquote. So having said that, I align with what Mr. Falana said in terms of journalists being forceful insisting in the vice president said for a virtual court proceeding, who sent out the invitation? If it's going to be court registrar, how many media houses? How does it determine which media house to invite for that particular court proceeding? Except the media houses are already aware, and if they are aware, if they don't have the link to that particular hearing, how do they be part of it? Well, even though I know that some of these establishments, sometimes they try to screen the media from coverage, because on 2 occasions I had challenged these infractions. One in 1992, when Justice A.L.A. Balogun of the Ikeja High Court, in a very purely a libel case, Benedion and I think Benedion sued one newspaper, and on his own, the judge just said that no reporter must report it. So, and I went to court. Fortunately, Anslem is here. Anslem was my counsel in that case. And Justice Okweagbe of Lagos High Court declined, didn't grant me leave to enforce my right. Then we went to Court of Appeal, and the matter was in Court of Appeal for a long time. So, and that one was another defamation case, Dr. Saraki, Olushola Saraki, and against Chief Ogundokun. And for reasons best known to the judge, he said that no newspaper must report it. And again, I filed an application to be joined as an interested party because I wanted to report it. But along that line, the two parties settled the matter out of court. So, and that ended the matter. So we think that just to align with what Mr. Fernando said, journalists must insist that we have, on no account must the media be shut out of proceedings, except it has to do with the issue of reporting minors or when the security of the country is involved. Otherwise, the media has to be involved. But the challenge I see in respect of covering the court, through a virtual device, is that, let me give an example. In the case in 1984, when I reported the report trial of Nduka Rabo and Tunde Thompson, because of the nature of Guardian house style, because Guardian tried to be different in the reportage. So when other newspapers will say, okay, so thing happened yesterday, the style of Guardian was that you look at some different perspective, human angle, story, intro, and so, for example, there was a time in which Rosie Williams came to court with a big dictionary, Webster dictionary, and that was where I started my story in 1964. That Rosie Williams came to court with big dictionary, and he came to court to define who is the publisher. Is it the reporter who is being, is it the two reporters who are in the dock, or the Guardian? So I took that story for that place. So, but if it was to be a virtual proceeding, perhaps it may not be, it may be difficult for me to actually know, whether Rosie Williams came to court with that kind of big dictionary or whatever. Or I recall that in those days when Gadefa Himi and Rosie Williams, an MBA, during the time of the litigation between Gadefa Himi and MBA. And usually I took my story from very human angle. For example, Gani with his very mischievous style, and Gani will come and it will try and belittle Chief Shofola, Mr. Shofola, Kenny Shofola. He will do like this, as if it's a short man. So, and then he will do like a Rosie Williams. We just make a jest of. So that kind of thing, I took story from that kind of person because to make it more humorous from human angle perspective. But that was because I was inside the court. Again, I recall when Major Debo Bashorun was about to be dealt with by Akilu. And he went to court suing Akilu and Chief of Army Staff. Then on every occasion during hearing, there are lots of soldiers at the court. Then one day, Major Bashorun now told Akabashorun, his counsel, that today is going to be different. That he had from very credible source that they went to abduct him immediately after the hearing, and that he will not allow himself to be abducted. That before they did that one, that he will have killed at least 3 soldiers. So he came to court, he wore an agbada, then came to court with 3 guns, and then he shot Akabashorun. So Aka called me. I said, come, we'll see what Debo is saying. That immediately after the proceeding, he just quickly run out of the court and go and stay at the Bushiri Street, and which was what we did. But fortunately, nothing happened that day. Debo was able to maneuver his way out of the court. Now, why am I saying so? That was the trust of my story, because Debo came to court with 3 guns. it wasn't even what happened, transpired in court that day was the story, but because Debo came to court with 3 guns. And I took it from that human perspective. So, but in the present circumstance, if we have virtual hearing, there was no way one would have known that Debo would have been in court with 3 guns, and how would have told his lawyer, I'm here with the 3 guns, and the lawyer would have whispered to another journalist that so things going to happen. So these are some of the challenges that one will see in this kind of hearing. And of course, you know, when counsels exchange processes, some of the processes are served right before the proceedings will start. Now, for a journalist who's in court, you have further processes from the counsel. But if he had to be in, if the reporter had to be in the comfort of his room or his office or his house, and fresh affidavit is being filed, how is he going to report that fresh processes have been filed and put that in a story? Because particularly for my Guardian background in the 80s, because you have to write lots of background to the story. Sometimes a new story will be about full page, sometimes two pages. And that's always a new story. So lots of background, you tie down so many things. But if it were to be a virtual court proceeding that is being proposed now, that will be a very difficult thing now, which is a major challenge that we are going to see in terms of inaccurate reportage. And of course, you know that once there's an inaccurate reporting in the news, that reporter is susceptible to contempt. And there have been instances in which a judge will try to cite a reporter for contempt because of inaccurate reporting. So, and that is for a reporter who was actually, physically in the court. But now that you are not physically in the court, and because of, for technical reasons, you cannot even hear properly what is being said, and you make a mistake by misreporting what happened in court, that poses a major challenge for the reporter. And that may, expose that by a reporter to dangers of being cited for contempt from misreporting court proceedings, which I think is a major challenge. But having said that, I agree with what the panel said. That reporters will insist, because there's some judges, even as magistrate court, that they, for reason best known to them, and they don't want to send a reporter in their court. But I believe that if the reporter insists that, well, we have to be in this court, we have to report this case. So, but now that if it's going to be virtual, who sends the invitation out? How do you get the link? And if you don't have access to the link, how do you cover it? And then you have to rely on another reporter who has the link. And supposing the reporter makes a mistake, then you to make the mistake. Both of you become liable. So that's a major challenge that I envisage in this reporting virtual proceedings. And of course, house styles differ from one part to a media house to media house. So if you have to adopt your house style to what happens in the courtroom. But of course, the use of technology is very crucial. It's very germane to this matter, because if you have bad network and you miss some parts of the proceedings, then what happens? Perhaps as one of the panelists had earlier said, the issue of live coverage becomes opposite in this circumstance, because I recall that the last Kenyan presidential election, the presidential petition was live on SABC. It was live on SABC. Throughout the period the presidential petition lasted. So I know that Kenya has changed and they're trying to available to some changes in terms of not following strictly common law, because they don't wear wig again in Kenya like we do here. So, and I think that South Africa too, they have changed in terms of going live coverage like Pretorius fire. But here in Nigeria, I mean, we need to adapt. And if there's going to be that live coverage, fine. But as Ruben said, who pays for the live coverage? Because it's quite expensive to have a live coverage. So which is a major challenge I've seen. But I believe that it's a learning process. It's a learning curve, which I think we get over it. But we need to start first, and then we make lots of mistakes. And of course, we try to perfect our mistakes. So I think that's my primary intervention for now.
Well, thank you very much, Richard Yakola. I mean, I agree with you absolutely on the various points that you have raised, particularly with regard to the practice of journalism. A reporter is primarily a reporter. And what we call a courtroom drama is very important. But if the journalist does not have access to witness that courtroom drama, he will be relying essentially on the eye of the camera, which is very selective, and it doesn't give a full picture. Yeah. And it's not just for the journalist alone, it's even for the judex. I mean, how does a judge, for example, determine the demeanor of witness? Because judges sometimes look at the demeanor of witnesses. How does a judge in a virtual hearing contest determine, for example, contempt in the face of the court? You can't determine that, you know, because you are relying on the eye of the camera. So there are many dimensions to it, and I want to thank you for, you know, bringing in this perspective about how journalists could be limited in describing the actual reality within the courts. But at this point, we have Professor Dinkalo, who has also joined us, and he is also like you, more or less on both sides, because he understands media practice extensively. And after Professor Dinkalu, you know, I'm glad also that we have here Professor Akinfeleye, a veteran teacher of mass communication and journalism, who will also be able to make his contribution. But after Professor Dinkalu's contribution, we'll go to question and answer, and I will go back to Shola Shoyele, who will take the questions and moderate that section. Professor Dinkalu, over to you.
Thank you ever so much, Egbon Ruben, and good afternoon, learned senior advocates. I think His Excellency the Vice President has got significant affairs of state at this point in time. Should I also apologize? I should apologize, I guess, that I joined a little late. I had to do daddy duty, sadly, or rather, gratefully. Let me. I'm also grateful to my good brother Moose for organizing this and the team at Gavel International. I was after listening to Egbon Femi Falana and my Oga Eternal, Richard Akinola, all I really should have said is amen. But I guess that will make me feel like a fraud. So just to try and exculpate myself from charges of being a fraudster, can I just say one or two things about this? First of all, I hope that if this is going to happen again, Gavel will obey its own rules or satisfy its own aspirations and make sure that this is covered live. Because I think we've got to live what we preach. And even if it is not covered live in the traditional way, we can also make sure that we have participation from other people. There is a vast digital community and digital citizen community that could benefit from these conversations. A hashtag would do, and people take it away from there, and it develops a life of its own. But it gets participation that is much bigger than the select group that we are here. Because really, this is about also whether we are able to practice what we preach. And central to that is the challenge of this conversation. You know, we all talk about this whole business of digital justice and coverage and all of that. and everybody is slicing it up in little salamis of ideas and conversations. But really, this is about reimagining how justice is delivered. Full stop. We have an incredible moment in time to reimagine comprehensively how we administer justice in our entire system. From the point of view of judges, from the point of view of lawyers, from the point of view of judicial reporting. And what is not often acknowledged is that judicial reporting in Nigeria as a genre was invented by Richard Akinola, for instance. And it's great to see him joined in this conversation and reflect the experience of time. And as I listen to him, I'm captivated by what I continue to call the digital analog paradox. And that is that we are at this intersection in which a lot of people are really confused about what to do. We are trying to make the crossover into digital imagination with a mindset framed in analog thinking and habits, and therefore we really are reluctant to grasp the fullest range of opportunities that this moment creates. It is quite true that we may not be able to capture Debo Basharun and, with, acting the, preparing to enact a wild, wild west in Igboshere High Court on a particular day. But digital proceedings are not bereft of drama. And some of them create new jurisprudence. And some of you would have listened to the situation of a judge who was caught on microphone when the microphone should have been turned off, saying some terrible things about a particular litigant in a particular case in which the judge was involved. That helped create jurisprudence, that helps create drama. Lawyers showing up in court in pajamas or their nightgowns, that creates drama, that creates new jurisprudence, and that creates learning opportunities, that creates teachable opportunities. And rather, we are fixated on history. History is very important, don't get me wrong, and nostalgia is fantastic. And we all are entitled to our bits of nostalgia and history. But that should not arrest us in a time warp that makes the future impossible to grasp. And when we think about grasping the future, the challenge is how do we reimagine the administration of justice? And that's why I'm a bit surprised that we are raising the questions about how do we do live transmission. Anybody can own a TV station these days. There are too many people with TV stations. YouTube is live transmission. Everything is live. But if we are thinking of live in terms of channels or Arise, that is a particular genre of live transmission. It does not mean live transmission does not happen. Live transmission does happen across platforms every day, all the time, and it is much cheaper now, and we cannot be thinking of it in terms of black and white television because that is history, full stop. Now, the question of live reporting doesn't, in many ways, it's been redefined. It's been redefined by digital, the digital market. It's really that simple. So the role of the court reporter is probably also got to be reimagined. In the past, the court reporter was there to captivate people with some drama of the courtroom. But maybe these days we are looking at a court reporter as an interpreter, as a translator, as a catalyzer of participation, as a catalyzer of co-ownership, because we are no longer thinking just in terms of judges, lawyers, and litigants. We are thinking in terms of a community of court users, the court or the courthouse as a convener of participation in dispute resolution as part of the democratic process, as a deliberative dimension to democracy, and in that and pacific resolution of disputes. And given that role, how does the role of the court reporter evolve? That, I think, for me, is a more challenging question to address. And given that, how do we update the skills of the different stakeholders and participants? That's why totally in agreement with the learned senior advocate, Mr. Falana, SAN. I have problems with the way the average Nigerian lawyer has approached this moment. Lawyering in Nigeria is in disrepute. And it's not just lawyering, it's the bar, it's the judiciary, it's everything about us. But that disrepute has captured this conversation, and we're thinking of this moment in Black lawyer terms. As a people, we are very tactile. The only things that exist are things that we can touch. And if we cannot touch it, it does not exist. That limits our imagination, that limits our creativity, that limits our civics, that limits our capability for change and innovation. And so we are looking at this entire disembodied process and we can't feel it. We can't touch it. It's not a courthouse. It is not anything that is Nigerian. It's not somewhere where we can go and spray money. And because we cannot spray money on digital proceedings, we want to return it to what we know how to do, how to spray money. And that really is the disappointing thing about this. All of the conversation about going to the Supreme Court or not going to the Supreme Court, I perfectly understand, of course, that some of the states that were involved wanted the Supreme Court to resolve that issue. And so they were involved in an intellectual strategic process. They were not really challenging it. But a lot of lawyers actually have genuine difficulties with digital proceedings and what it entails, just as reporters do, and some citizens and court users do. And there are some practical issues that obviously will need to be addressed. The issue of taking evidence from live witnesses is one, but lots of proceedings no longer do not need live witnesses. And therefore, that level of objection has to be seen as limited. The issue of how you object to, or the objections in the light of Section 36 to digital proceedings, the Supreme Court did not actually resolve, by the way. The Supreme Court decision was on a technicality. So the substantive challenges, we are citing that Supreme Court decision as if it actually dealt with those issues. I can bet you most of the justices that dealt with the issue of the Supreme Court know very little about digital justice and what it entails, and couldn't be too bothered to engage with those issues. And the judges who know a lot about digital justice in Nigeria are not in the Supreme Court, like the Chief Judge of Borno State, for instance, or one or two on the Federal High Court, whom I don't want to embarrass positively by naming them here because maybe they will not get promoted after that. But really, that is the issue. How do we, it's like the chain of promotion and judicial advancement. Given where we are going, how do we work through to make sure that good judges or good justices or enlightened judges get work through the system in a way where they can bring their skills to affect the cascade, the policy institutional cascade down the system? We're not thinking about that. What are we thinking about? Who's going to award the next contract? So that contract will enable us procure hardware or procure software. And that is the Nigerian thing that tires me out. And when you talk, they say you're shouting too much and you're abusing people. But we have a country in which young people are asking awkward questions that their parents cannot answer. And the answer that their generation of their parents is willing to give is clobber them, imprison them, detain them, shoot them, kill them, close off their opportunities. And that is the mindset that continues to frame this conversation. That's why some of the stuff I hear is very painful. We are not thinking as a generation, and most of us who are speaking here of a particular generation, Nigeria's life expectancy is 53, 52 and falling. And most of us are close to 53, 52 or above it and are living on borrowed time. But we want to close the opportunities of the younger people who are now in a position to advance things beyond the imagination of this Nigeria's leadership generation. That for me is the challenge here. That's why what Gavel has tried to convene here makes a heck of a lot of sense to me. But I'm hoping that this is not the end of the conversation, but rather the beginning. That after this, proceeding from this, we are going to be able to get to discuss with judges, with journalists, editors, publishers, news proprietors, and we can get lawyers. The new president of the Bar Association is promising something new, and there is a body called Murik MBA or New Nigerian Bar, depending on which one you want to take it. But whatever we call it, can we take this thing to those people who would rather be discussing the protection of an El Rufai rather than the protection of a young man whose life is going to be snuffed out by the governor of Kano State? They will not see that. They will not see the young man, the humanist who's been in detention and who is probably not going to get a trial. They will not see that. What they will see only is the backside. So forgive me for being graphic, the backside of a politician who is begging to be licked. If we continue this way, the promise of digital justice is going to be wasted, and the abuse of analog justice is going to be elevated. If that's the country you want to live in, may the last person to live it please turn out the lights. Thank you.
Well, points well made, Professor Chidi Odinkalo. You are calling for thinking out of the box, transformation, creativity, innovation, involving, and trying to acquire new skills and moving from an analog age to the digital age. You've raised very interesting issues that I believe will still come up in the conversation, which, as you have indicated, is just beginning. This should not be the end of it. And I hope that Gavel International will make the outcomes of this conversation available to a wider audience that has not been able to take part here. Now I'll hand over to Shola Shoyele, who will moderate the question and answer session. Shola, over to you. Hello, Shola, did you hear me? Hello? Hello?
Shola is available, Doctor.
Yes, Shola, over to you. Let's take the question and answer session and extend the conversation further.
I'm not sure Shola is available now.
Oh, she's not available. Okay, we've been having this session with the Vice President, and then we've had the lead discussant, Chief Wole Olanikwekun, represented by Chief Bode. No, I say Chief. Yes, he will be chief too someday, represented by Bode Olanikwekun. And then we've had Mr. Dele Adesina SAN, Femi Falana SAN, Richard Akinola, and Professor Chidi Ansem Odinkalo. I understand that we have in the house, as part of this exercise, quite a number of persons, including, as I pointed out earlier, our teacher, Professor Akinfele, Gbenga Oyebode, CFR, Adeola Fashuba, Pamidele Johnson, who is also a journalist, and Dr. Isheolua Ige, and others. So we'd like to take comments from persons who would like to make comments or questions for specific discussants who have been part of this program. Who is going to go first? Hello? 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 Can you hear me?
Yes, we can.
Yes, I was saying who will go first to make a comment or ask a question. Please identify yourself and then please proceed briefly.
I've raised my hand ever since.
Okay, I wasn't seeing you on the screen. Please introduce yourself.
Okay, my name is Jude Igbanoy.
Okay, I know that name.
Okay, I'm deputy law editor of This Day Lawyer, This Day Newspapers.
Yes.
I'm quite intrigued by the proceedings so far. But I'm a little worried about some general assumptions that we have heard today. For instance, I think too much emphasis is being placed on courtroom reporting, journalism generally. I don't think the kind of garb with which we dressed judicial correspondence at these proceedings is a little bit worrisome to me. But if we are saying that the public, the judges are going to rely on journalists, basically, it will create problems, because what some of us, or what those who are outside of journalism don't know, is that the crop of journalists we have these days are not as reliable as we used to think. Today, I know for a certain, and I'm in the field, I'm not, this is not to disparage my colleagues in the field, is that if a matter is going on, for instance, journalists are gathered by different litigants they are mobilized, they are paid to report from a particular angle, which may not reflect the issues, the factual issues in the case. Forget about virtual proceedings. If, for instance, a reporter from a media house is given by, is mobilized by a litigant, he's going to report strictly from the perspective of that litigant, thereby potentially misleading the public. So I don't think we should give so much credence to judicial correspondence. That's number one. Then my second observation, because of time, I quickly want to make I have many things to say, is that I think this idea of virtual reporting or virtual proceedings is laying too much emphasis on trial. What happens? I think I understand the concern of everybody, quick dispensation of speedy dispensation of justice. But what happens at the appellate court? If you quickly hear a matter like the president said, dispose of a matter within a year, it goes on appeal. Where does virtual proceeding come in at the level of Court of Appeal? Are we going to allow it? Is it going to also hasten or fast track proceedings at the Court of Appeal and the Apex Court? Those are areas we also need to extend our minds to, because we must think into the future. Right now, we are dwelling too much on track. It's already assumed that we have settled the issue of trials at the trial court. I mean, if the Supreme Court has said it's okay, go ahead. No matter what anybody thinks, it becomes academic and relevant. So let us look at the appellate court and ultimately the apex court. To what extent can we virtually hold proceedings at those courts? Those are some of my concerns.
Okay, thank you very much, Judy Banoy. But you brought in something also about professionalism and ethics in journalism that should be of interest to people like Richard Akinola and Chidian Semodinkalo and Professor Akinfeleye. Maybe perhaps there's also a role here for media owners to ensure the integrity of the reporting process, whether it's physical or virtual. So who else wants to intervene? But if nobody is indicating interest, I would like to call on Professor Akinfeleye to please say something about judicial reporting and the responsibility and the challenges that journalists face. Prof, if you are still with us. Hello? Hello? I was calling on Professor Akinfeleye to make a few remarks.
I'm ready. Can you hear me?
Yes, sir, I can hear you. Please go ahead.
Okay. Thank you, Ruben, as usual.
Yes, sir. Thank you, sir.
I want to congratulate everybody for this special seminar, particularly the Gavo International and the speakers for today, especially the Vice President of the Federation, and of course, who was the keynote speaker, and also the excellent presenters. First of all, you can hear that my generator is working. So that's part of the problem. I've put on my generator throughout because of the interest I have in this seminar. I want to say that I concur with the sentiments expressed by Richard Akinola and my brother Femi Falana, and of course Chendi. And yourself also, Ruben, because you have played our role. Even you are moderating, you are speaking our minds out. I also like to mention that also that there are two remaining estates that are naturally useful to this country. Falana said Nigeria are not serious people. To make out to be serious, I think these two institutions should also be serious. These are the media and the judiciary. The other estates have been infected with viruses and they need antivirus. Nigeria will be finished, according to said, if these two estates, these two institutions are not allowed to properly function. Yes, I raised two issues here. The issue of the vice president says that virtual court proceedings constitutional. Yes. About access, about the issue of advocacy, virtual versus face-to-face. The questions that there's a need for, but live coverage is expensive. Then I ask the question, who pays for the live coverage? And if you are recording, you still pay. Who pays for that one? And then you will lose the dynamics in the court hall. We engage the judges and the like. I won't enjoy advocacy through virtual. It's better for me to go ahead. Then I'm trying to suggest, my dear brother, that the question of the social media and the question of the mainstream professionals. You are aware some of the social media people, though they may be trained as journalists, but some of them, in my judgment, have not been practicing journalism. They are practicing what I call journalists. And therefore, I call some of them information carriers. And my best description of those few people who are not practicing journalism, I call them information traffickers. The traffic on information, on the traffic on falsehood, and try to debase the spirit and ethics of journalism. Action hybrid in view of the to participate. Hello? Hello? Lord,
we're with you, sir. Hello? We're with you, sir.
Yes.
We're with you, sir.
Yeah, I was trying to conclude that the issue of mainstream journalists and the so-called social media people. I said some of them are not practicing journalism. What do they practice? They practice journalists. And therefore, I call them information processors. And my best description of those who practice journalists, I call them information traffickers. They traffic on falsehood and they try to speed up their falsehood, thereby trying to discredit the mainstream journalists. But are you going to kill them? No, they must work simultaneously with the mainstream journalists. And I said, well, in view of the contending issues raised by all of the participants, I asked, can't we try a hybrid approach? Hybrid approach, a bit of virtual, a bit of face-to-face in the interim. Thank you, sir.
Well, thank you very much, Professor Ralph Akinfeleye. I'm sure that lawyers in this forum will say, well, even when you are an information trafficker and you misrepresent the court, hello, you can be charged.
Hello.
Hello, sir.
Yes.
Hello.
Yes, I'm hearing.
Yes, I was saying that, you know, the lawyers in this forum would readily agree that even when you are a social media information trafficker or processor, as you call them,
yes,
you can be charged for contempt away from the face of the court. So that's one protection there, yes. But we'll take more comments or questions, as it were. Who is going to...
Thank you, Ruben. I'm fully protected. Yes.
So who's going to intervene next? If Mr. Gbenga Oyebode is still with us, I would like to invite him to also say something or raise further questions?
You want me to comment?
Yes, Mr. Ibode. Hello?
Good day, everybody.
Good day. Okay, I see Collins Okamadiri on the screen.
Yes, good day, everybody.
Good day.
Okay. First of all, I must start by stating I'm really privileged to be part of this very great webinar, and from all the panelists, their submissions have been quite really excellent. Okay. So my question is actually with regard to evidential issues that come with visual hearings. So even though great minds like His Excellency the Vice President has stated that he actually has brought this issue, to the fore, why this webinar was going on, and has mentioned that practice directions could be used to solve some of these evidential issues that come with visual hearing. We still cannot deny the fact that the Evidence Act happens to be our primary legislation on evidence generally, and practice that to be inferior to the Evidence Act. So how exactly do we settle this issue with respect to evidence in visual proceedings? Does it need us to amend our Evidence Act, or would it need us to suspend some part of it to accommodate tendering of evidence through visual proceedings? So I'm really concerned with how exactly do we solve evidential issues, because I am part of the school of thought that welcome visual proceedings as the way forward, considering the peculiarities of the circumstances we are all in currently. Thank you very much.
Okay, Collins Okamadiri has raised a very interesting question. I don't know who would like to respond to that. Bode Olanikwekun, would you like to take that question? Or maybe Dele Additional SAN or Femi Falana SAN?
All right, thank you very much, Mr. Abati. There's no doubt about the fact that there are issues with, or there are challenges with implementing or deploying virtual hearings. But like I believe, and I've kept on saying, these are not issues that are insurmountable. I would give few instances. One of the issues is demeanor of witnesses. Demeanor of witnesses. Now, there are quite a number of Supreme Court decisions that actually say that the demeanor of a witness can be misleading. So it's not absolute. A witness could look at you straight in the face and tell you a lie without giving, without showing on the face. I mean, I think it was Shakespeare that said that there is no art by which you can know the construction of the mind from the face. So there are experts in telling lies. Now, talking of demeanor, you can actually view the demeanor of a witness virtually. All you need to do is to zoom in on the face or pinch out your screen. You will see the demeanor of the witness. Now, issues of witness coaching. The Evidence Act provides that when a witness is given evidence, all other witnesses should be out of hearing. Now, how do you ensure this in a virtual hearing where people are at different locations and you don't know if the witness is being coached? My simple solution to that is this. It should be open to the adverse party to put a representative where witnesses are given evidence. So if I'm the plaintiff and the defendant is given, the defendant's witness is given evidence, I should be allowed to put one of my representatives at the location where the defendant is given evidence. I think that will solve it. original documents. You know, we place a lot of emphasis on, you know, tendering original documents and all of those. I would think that the basis for insistence on tendering original documents is to establish genuineness. So if we move away from the technicality of, oh, it must be original, to ascertain the genuineness. So, I mean, if I bring the photocopy of a genuine document, in any event, the law says that I cannot use oral evidence to alter the contents of a document. So if the contents are accepted as true, whether it is original, whether it is photocopy, whether it is torn, so far it is legible, I think that it should be admissible. In any event, a way around all of this is this: tender your documents in bulk, push them in. At the end of hearing, we defer all objections to the end of hearing. At the end of hearing, all parties have the right to inspect the documents that have been tendered. So anybody that doesn't tender an original document does that at his own risk. So objections can then be taken at the close of hearing. And I think that solves it. One very serious issue I've been trying to wrap my head around is visit to locus inco. How we can, you know, how we can apply virtual hearing to visit to locus inco, because the Evidence Act says you gives options that you might adjourn sitting to the locus. I think a way around it, if all parties agree, is that a recording of the locus inco can be made where representatives of all parties will be at the recording. They sign off on the recording and submit it to court. So I don't believe that there are problems that are insurmountable. I believe that these problems can be surmounted. But I would say honestly that I have a fear that these issues of virtual hearing might just end at conversations. And I mean, I've been going to court consistently in the past few weeks. I was in court today, I was in court yesterday, you know, and I've not heard any lawyer say to me that they've participated in virtual hearings in at least the last 1 month. And well, there are senior advocates of Nigeria on the panel here. They can't tell us if they have participated in any virtual hearing, unlike when, you know, this whole thing about virtual hearings started. The few courts that conducted virtual hearings publicized them so much, but really, in practicalizing it, it's all died down. So it might just be a fad of the moment or a cliche. That's my fear, because we're going back to normal. And to be honest, if we say that virtual hearing is the new normal, I don't think it's true, because we've come back to what we were doing before. Thank you.
Okay, Daily Additional SAN, I see you on the screen. Let me come to you. You have heard what Bodiola Nikwekun has said with regard to evidence responding to Collins Okamadiri. You know, we'd like to have your take, and also perhaps with regard to arbitration and virtual hearings. Would that apply? Would that, what should be the procedure in that regard?
I will just add to what Mr. Bodiola Nikwekun SAN said. With regard to taking of evidence, today we have what we call front loading. All documents are front loaded. All right? At the time you are filing either your statement of claim or statement of defense, you also front load the documents you are going to be tendering. And there are instances where, even where you cannot lay your hands on the original, if it is a public document, you tender a certified true copy. If it is an ordinary document, once you can give foundational evidence to why the original is not available, you tender photocopy. So there is no hard and fast rule to this. It must be original, it must be original, it must be original. With regards to demeanor, please let me quickly recall one statement which I've never forgotten since I had it. I was before Honorable Justice Ilori Chief Judge of Lagos State High Court many, many years ago. And an issue arose. A counsel took objection to what another counsel was saying from the bar. And the counsel went ahead to say, if my learned friend wants to give evidence, let him enter the box and I will cross-examine him. And his lordship interjected and said, what are you talking about? I will believe a statement made by a lawyer from the bar 10 times than I will believe a statement made by witness in the witness box. So that you are face to face with a witness in the witness box does not mean he's telling the truth. A very good examiner will tell you that he knows when a witness is telling lies or not. When you are cross-examining a witness, you know when he's lying in response to your questions, and you know when he's telling the truth. It flows. When somebody is telling the truth, it flows. But when he lies, and the cross-examiner knows that this is a lie, you know, it will veer off, ask some other questions before he comes back to the very point that he wanted to get. If he had wanted to ask only one question, he may end up asking 6, 7 questions. And the fellow will continue to contradict himself on and on and on and on. So there is no system fashioned out by man that can be perfect. There will always be some little minuses here and there. But once the advantages are more than the disadvantages, then we go ahead, we go along. That will be my response to the issue of evidence, to the issue of tendering of documents and what have you. And like it has rightly been suggested, if we can do it in election petition cases, why can't we do it in normal hearing? And like a friend of mine will always say, Mr. Femi Falana, why are the political cases much more important than commercial cases? If time is of essence in political cases, in election petitions, why is time not in essence in commercial matters, business matters? So whatever objection that you have, raise your objection, file your written address on that objection. A final decision will be taken by His Lordship at the end of trial. I think with all this, we can surmount the problem. But I must make the point that all this must not end at conversational level. A few weeks ago, what's the name of the judge again? James. We appeared before Honorable Justice, don't let me mention her name openly. We were here in our office on Opebi Road, and another counsel was in his office somewhere in Ebutemeta. His lordship was at Iboshere, and we had a trial. Although there was no calling of evidence, but we couldn't have done more than what we did in chambers if we had physically been present before her. So some judges are taking on virtual hearings, and it's proceeding on well. I've also appeared before another judge in Ogun State very recently, and I had to tell His Lordship, I said, I hope our next adjourned date will take place through virtual hearing. And surprisingly, the judge was telling me as if I was speaking Greek. He said, when we get to the bridge, we will cross it. Which bridge? Is there a bridge in court? You know? So we also must deal with issue of attitude, not just on the part of the lawyers, issue of attitude on the part of the judges. This is very key. But we need an instrument that will drive this process. It's not a fire brigade approach that will solve it. Thank you very much.
Yes, Mr. Femi Falana, SAN, over to you. Would you like to comment on this interesting subject? Hello, Mr. Falana. Hello, Mr. Falana, are you still with us? Okay, Mr. Falano is not available. Professor Giancarlo, I'd like to invite you to make some comments about this issue of evidence.
Thanks a lot, sir. And I think most of the issues I'd probably have wished to address have been dealt with by the two learned senior advocates. So can I just limit myself to two? One is illustrative and the other is a foundational point. The issue of demeanor.
Ruben.
Okay.
I'm here, Ruben.
Okay, Mr. Falano is back. Yes, I was calling on you earlier to comment on the issue raised by Collins Okamadiri.
It's already after 4. I will leave at 4.
Serious people. And that is where Mr. Olanipekwese ended. He has challenged us to tell him which of our courts have gone beyond our virtual discussions. Even though Mr. Additional has mentioned only one, I haven't participated in any virtual hearing in Nigeria, but I've indicated, I've said it before, I've taken part in virtual hearing, virtual proceedings in the Community Court of Justice in Abuja. In fact, that court has already abandoned physical hearing of cases. And that is the trend. Kenya, about 4 months ago, had already released about 5,000 prison inmates by virtual hearing. But here, we are not ready. Even when some of the judges are ready, they say, oh, your colleagues say they are not ready. So, and that is why I've suggested, after this discussion, let the organizers of this program, my very good friend, Mr. Ogunshakin, let him contact some of the senior lawyers who believe in virtual proceeding, virtual hearing. What can we do to move this system forward? The practice directions have already allowed virtual hearing. Now, the other issues raised by our colleague, again, it still shows our backwardness. I mean, you ask yourself, visit to the locus cinco. I've been in practice for 38 years. I don't know how many times, we've done a visit to locus cinco in recent time. Then some of these procedures belong to the past. And what is locus cinco? You want to visit the scene of maybe there is a dispute over a plot of land. No, you go and get a surveyor to produce a composite plan. Why do you want the judge to go and look at a plot of land? Again, it's even backward. If we believe in land documentation, you don't need to be telling stories in court. It was my father that gave the land to his father, and so on and so forth. And I have said it before. You want to buy a plot of land, a property in England today, in South Africa, even in Ghana to some extent. Once you have the address, you connect, you find out from the internet, and you have the history of the land. Whoever has had anything to do with the land. But here, it's all about going to call witnesses, amending the processes because some of the witnesses die in the process during the case. So please let us move. If you want to have locus cinco, somebody is dead, we won't go and what do you want to go and visit where the man died? When the doctor can produce, evidence of death, post-mortem report, So why do you waste our time? And then we are still clinging to the past. The meaning of witnesses. Again, I'm not sure, and my reading may be limited here. I'm not sure I've read a notice of appeal where somebody says the learned trial judge heard in law in not attaching weight to the demeanor of witness A. I don't understand it. Most of the time, a judge is writing his judge. It has nothing to do with demeanor. Particularly now that essence of our case is documentary. The law deals with the documents in the court. And like my learned brother, Olanikwekun SN has said again, you cannot bring oral evidence to vary the document before the court. So please let us move. Then when people say, you must bring the witness, I had the case recently, it's still ongoing. My witness is in the US, known to all of you, Olumese, Sonala. Now, I wanted to file his witness statement. And my colleague said, oh, sir, we need to bring this witness from the US. I said, do you know what you are doing? For somebody to come all the way from the US to come and sign a document, please go and read your law. And I simply called the man, please, can you sign your witness statement before a notary public and send to me? And that was what we done. And we filed it in Abuja. Of course, I think a learned senior advocate is on the other side, Chief. Let us take advantage of the new practice directions to move our system forward. And as I've said, we are not a serious people. Lawyers are the people now saying we are not ready, including senior advocates of Nigeria. You know, why do I need to do? And once a party objects, because say, sorry, your colleague does not agree that we should have virtual hearing, therefore let us move forward. The final one, please, and I've had this experience in some of our courts. Again, I ask people, if a worker has been sacked, you have the conditions of service, the letters of employment, the letters of disengagement. Why? What? To commit.
Hello?
Hello, I'm with you. Hello? Hello?
Okay, can I just try and I'll cede the floor to Igbo Femi once he shows up. Mr. Falana?
Okay, Professor Dinkalo, please go ahead. Go ahead.
Okay, just continuing, because he's really laid the groundwork for this. This is about thinking possible. And I think Bode Olanikbeku, senior advocate, also made that point. I think Nigeria is a country in which we major habitually in the minor. We waste our time in things that are just, hello?
Yeah.
Yeah, okay, sorry, sir, please.
We can hear you.
Yeah, you know, I was saying we major in the minor very balefully. And yes, these questions that we are talking about shouldn't really engage a serious community. Look, the people who are telling you about demeanor have never met Donald Trump, but they all have impressions about him from watching him on TV. I don't, because all of this evidence act, that's just annoying me. Yeah. If you ask this person who asked this question now, what does he think about Donald Trump? He will tell you. He has never touched Donald Trump. He has never seen Donald Trump or except on TV. He has impressions about him that are fully formed. But the person will come here and start telling you about Evidence Act and demeanor. Yes. Now, this same person, now last week, Chadwick Boseman died. Nigerians broke down crying. Nigerians who had never been to Wakanda were crying. None of them has ever seen Chadwick Boseman. They were so in love with a person they had never seen, they were crying. But we are discussing demeanor here. These are the realities of demeanor. But we are unable to do the mental migration required to address our realities because we see these things as disembodied from our realities. The demeanor talk, as the proper lawyers here have said, the learned senior advocates, is quite frankly, forgive my use of the expression, utterly nonsensical. Yeah. Nobody who has done litigation, I only did very little before I ran away because I saw Moshood Olugbani collecting bribe in Lagos to issue, I will give his name. He collected a bribe to issue a ship arrest, and I swore over my dead body, will I continue with this thing? It is going to kill my soul. And I ran away. But this is so I respect people who have continued with that thing of watching judges give bribes and then take bribes and give orders and continue to call them my lord, because I can't. Now, when you are in this position, you know, of the experience, the combined experience of the learned senior advocates of well over 100 years, ask how many of them the number of times demeanor has unsettled a decision. The likelihood is zero.
I don't understand demeanor.
So there is only one. Now, I will add just one modest dimension to this. Locus in quo, and I absolutely agree with Bodo Olanipeku, senior advocate. There is only one modest issue here. Depending on the scale of the case, geospatial evidence can help us address locus in quo, but you will need to deal with geospatial evidence in a case that really requires it. What's that? Satellite evidence. Now, yes, in the human rights sphere, we make use of geospatial evidence very easily. And I'll give you a practical example. When, as chair of the National Human Rights Commission, I had to investigate Baga, there were reasons. The Baga massacre, if you remember in 2013, Dr. Bati, you were in government at the point.
Yeah.
There were reasons why we could not go to Baga. I was supposed to go with General Wali. And we could not go for practical reasons that I will not go into here. What happened? We went to geospatial evidence. We went to, and if you know about geospatial evidence, you can get resolution to about 2 feet of the most astonishing pieces of material. And all we did was go to the Nigeria satellite, the institution, what's it called, NICHCOMSAT. We deal with geospatial evidence in Nigeria. We sat down with them and they gave us geospatial evidence on Baga. Very few people will know this, but that's exactly what happened. We did not need to go outside Nigeria. And it did not cost us a dime. Actually, it saves us a lot of money. And geospatial evidence is available in many cases to address what we do with, you know, apart from, in addition to what Mr. Falana said, it will help us with some of the major cases where we need to do what we have called visit to locus. Visit to locus really is for rural areas where being a lawyer is a big thing and going to intimidate people is a big thing. Lawyers get paid in plots of land. That is history, and we should really consign it to that. Thank you.
Yeah, thank you. Thank you.
Well, thank you very much, Bodo Olanipeku, SAN, Mr. Dele Additional SAN, Femi Falana SAN, and Professor Dinkalo. Mustafa Ogunshakin, we spent quite some time on this conversation, but I would like Richard Akinola to make concluding remarks. And if the Vice President is still available, maybe we'll also invite him to just make some closing remarks. But at this point, Richard Akinola, if you are still with us, I would like to have your final thoughts on some of the issues that have been raised in the question and answer session.
Before Richard, Ruben, since I'm not coming back.
Yes, sir.
Hello?
I'm with you, sir.
I have challenged the media. Why are you not insisting on the coverage of a judicial commission of inquiry? The EFCC matter affects all Nigerians. So why don't we live here determined to do your work as journalists, that we're not going to allow secret hearing of serious matters that have to do with the interests of our country? Thank you.
Yes, Richard Yankala, over to you. Hello, is Richard Akinola still with us? Yes, please.
Yes.
Okay, please go ahead, your concluding remarks on some of these issues that have been raised.
He's a reverend, though.
Well, maybe you'll bring it to a close with prayer. Hello, can you hear me?
I'm not sure Mr. Akinola is here away.
Okay, he's no longer with us.
Enemies have taken me away.
Okay, Mustafa, what's next? Is His Excellency still with us so that we could invite the Vice President? I
think His Excellency has left too.
Oh, okay.
I think he had an assignment, another assignment for 4.
Okay.
So he had left.
Well, we want to thank him for joining us. So what do we take next? National pledge or the vote of thanks from you?
Maybe I just take the closing remarks for
okay.
Yes. This humbly
Only
to
Mustafa
thank
Ubishaki.
everyone. Thank you, Doctor. May I humbly thank everyone that has attended this webinar. It's really an eye-opener. And believe me, I think it has even expanded the issues more than I thought. Just this morning, I was discussing with my wife about my thoughts concerning the webinar. I was solely thinking of how journalists will be able to do their work unfettered. But then, after, with all these our discussions, I realized that the issues are even much more than that. Like some people have asked, why can't we have video coverage of courts? Why can't we, all journalists, whether you are known or not known, why can't there be a particular link that all journalists will click to watch court proceedings at any particular point in time, at anywhere? We have seen it outside this country. And I think in weeks and months to come, Gavi International is going to be liaising with other organizations to really start campaigning for open court proceedings, where it's even in the advantage, is to the advantage of both the judges and the lawyers. Just a few days ago, I watched a film concerning one United States Justice of Supreme Court, Lady Ginsburg. Lady Ginsburg was one of the people that fought for the emancipation of women in America. And presently is an associate justice of the Supreme Court. In that film, we could hear his voice when he was making his advocacy before the Supreme Court. Why can't we have those kind of things here? We have great judges in Nigeria, the late Justice Soputa, the late Justice Kayo Edeosho, and the rest of them. Their voices are lost permanently. We will never have that again. Can't we shake things and begin to record our justices and to record our lawyers as they make great advocacy before our courts? So that even if there are issues within the society, like the voice of Martin Luther, we could play all these things to rejuvenate the society. And all these things, I think we have to look at in the weeks and months and years to come. I thank everybody for attending this webinar. Particularly, I want to thank my wife, who have done all the works, and two young men, Mr. Ayo Lumoko and Mr. Kendi Falade, Dr. Falade, for the wonderful work they have done in putting this together. My colleagues, Mr. Judy Banoy, Mr. Debisi Ononuga, Mr. Peter Fuyo, Moji, and my Lord, just we call him my Lord, Mr. John Unashuku, the Judicial Editor of the Nation. They sat down with me here and will listen to all this. So thank you very much. God bless you, everyone. To you, Doctor.
Yes, well, you've already done it. The vote of thanks. Thank you, everyone who have been part of this. This has been quite exciting. And we hope that Ogunshaki, you will take this further and make some of the recommendations and observations available to a wider audience. Thank you very much, everyone.